What's the best way to protect your family and ensure that your assets are administered exactly like you wanted them to be after you're gone? Which is better, a will or a living trust? I'm Jeff Hampton, asset protection attorney and founder of STR Law Guys. In today's video, I'm going to break down the key differences between a will and a living trust, why it matters to you, which one is best at protecting your family's needs and making sure that you are able to take care of your desires for your estate without unnecessary complication. First of all, why does it even matter? Well, if you're like me, I want to make it as simple and painless as possible for my family after I'm gone. Whether you have estate planning documents or not, the way your assets are handled after your death will significantly impact both the financial and the emotional well-being of your family. The big debate always centers around probate court. We've all heard that we should try to avoid probate court as much as possible if we can, and there's a good reason for people to say this. So in order for us to really understand the difference between a will and a trust, let's first examine probate and why it's important for you to stay out of probate court. So what is probate? Well, probate is essentially, and here's what's key, a court-supervised process for which the court helps your family decide how the distribution of assets should take place after you die. Because it is court supervised, the big negatives here, it's all made public for everyone to see, it's time consuming, and of course, because you have lawyers involved, it's super expensive. What's the role of a will? How is a will going to help you with probate? Unfortunately, a will does not keep you out of probate court. A will simply informs the court who should receive your assets. Without a will, the court will decide who receives your assets based upon state laws, known as intestacy laws. So I'm going to give you a couple of quick reasons why you should consider avoiding probate court. Number one, as I mentioned earlier, it's public. It will make all of your financial affairs public record for people to see, which brings out the predators. It brings out all the scam artists and all of that. They will be preying on your family during this period of time. So you don't want all of that to be in public record. Number two, it can take up to 18 months or longer to complete the probate process easily. So that means your assets are being held up in court. And of course, that means more money being paid to lawyers. And here's the worst part. If you're a real estate investor like myself, and maybe you own some properties in multiple states, it will require the probate process to take place in each and every one of those states where you own property. Think about what that does. That now adds even more time to the process. It also adds even more costs, more attorneys that you have to hire. It's just not worth it. Now let's compare all those negatives of the will with all the benefits of a living trust. Here, if you set up your trust the right way, a living trust can help you avoid probate court entirely. So how does a living trust work? First, let's identify asset ownership. Essentially, all the assets you have in your name, many of them you can choose to actually transfer into ownership of the living trust. Now, not all assets need to be put into your living trust, and I cover a separate video on that subject. But here, this means during your lifetime, if you transfer the right assets into your living trust, you now can manage those assets, but you no longer own those assets. They're a part of trust ownership. And remember what a trust is. A trust is basically a contract with property rights. So you're able to manage everything and control it, just like you have before, but now it's already a part of the trust so that you don't own it. And the reason why it's important you don't own it is that because it's no longer part of your estate, according to the law, you don't have to go through probate court in order to deal with it. You also are able to maintain control and flexibility. So I mentioned earlier you're able to maintain all the control over the assets within the trust. That's because you can appoint yourself as the trustee during your lifetime. This gives you total control and flexibility to manage those assets as you see fit. Upon your incapacity or death, your successor trustee steps in and manages those assets in accordance with your wishes and your desires. The power you give to your successor trustee can be something that's provided automatically as part of the trust, or it can be something that's provided over a period of time, so that way you can help protect against financial missteps. Remember, that successor trustee, whoever you name, also now has a fiduciary duty to act on behalf of your beneficiaries to make sure they make the right decisions. But what about distributions of the trust? What if there are assets within the trust and you want to make sure your beneficiaries receive them? Well, if your beneficiaries at the time of your death are mature and they're ready for those distributions, you can have them outright distributed and the trust can be dissolved. What if you have younger children? What if you have grandchildren? What if there's specific provisions for younger beneficiaries? There you can have age-based limitations for those beneficiaries that only take hold based upon the age of each beneficiary. The next option is you can do what we call a time-based distribution, where here some people are a little worried that if they pass away and they receive, one of their beneficiaries receives a windfall, let's say it's a 22-year-old in college, and he gets a windfall, he might squander that windfall. So you can actually spread that distribution out over a period of time and make it time-based. Finally, you can also create a legacy trust where the actual principal of the trust is protected and not distributed, and only the income from that principal of the trust is provided to those beneficiaries for their income. Now, we've covered the benefits of a living trust compared to a will, and we've spent a little bit of time about how distributions work. But what about the actual protective provisions of a trust? Now, it's true, if you use a revocable living trust, you don't receive any asset protection from, say, greedy lawyers that might be suing rental property within that trust. However, there are certain provisions that if you draft your trust the right way, can provide you certain protections. So let's identify those. Number one, let's talk about spendthrift clauses within a living trust. A spendthrift clause is really important to consider within a living trust because it prevents creditors from accessing trust funds unless there's a distribution. Number two, you can provide a special needs provision. This is really important if you're concerned about government benefits. It still allows for the trust to provide support without jeopardizing those government benefits, especially if you're talking about like Medicaid. There are special provisions you can provide for Medicaid and Medicare type trusts. You can add them into a living trust. Number three, a separate property trust. This is really important if you want to ensure that an inheritance remains separate from a beneficiary's marital property. This is really good when it comes to maybe a remarriage or you're trying to make sure that you're separating out certain property from other property. Number four, what if you want to add a financial education requirement? I see this happen a lot with clients where they'll come in and they'll say, listen, I want to provide a certain amount of property within the trust to a beneficiary, but I need them to graduate from college first. And that's only going to be provided to them if they meet the graduation requirements. Finally, number five, what about discretionary drug testing? Now, this is important, particularly if someone wants to give to their grandkids or they're trying to give to maybe someone who's not an immediate family member, but they want to make a distribution to someone. But the requirement is that they meet certain drug testing requirements in order to make sure that there's no drug abuse going on at the time of the distribution. So when deciding between a will and a trust, it really comes down to control and protection. And I don't know about you, but I don't want the government into my estate if I can help it. And when you use a will, you really put yourself at a government-directed distribution of your assets. A will leads to minimal control and almost always leads to probate court. A living trust, on the other hand, provides a detailed roadmap for your assets, your privacy, and total flexibility. To me, estate planning is about setting up your legacy to both protect your loved ones, but also make sure that your wishes are followed at the time of your death. But what if you decide to move forward with the living trust option? Did you know that there are certain assets you should never put in your living trust? Check out this next video where I break down each asset you should keep out of your living trust and exactly the strategies you need for your trust management. See you over there.